I'm talking about, we talk today about child abduction. When we talk about child abduction, really what we're talking about, or what I'm talking about, is parental child abduction, where one parent absconds with the child in the course of their breakup and denies access to the other parent. It's a growing international problem, and one that Japan has been identified with for some time now. I actually had to modify this slide just because this latest article was a nice example from Stars and Stripes. More countries join fight against Japan in child abduction cases. October 25th, 2010. Just a few weeks before that, the U.S. House of Representatives passed a resolution calling on Japan to do something about its child abduction problem. Japan is generally understood among international family practitioners to be a haven for international parental child abduction. This resolution is quite long, but I've introduced some select parts of it because I think they provide some useful historical context. Growing problem of abduction and retention. So abduction is when the common pattern is a Japanese spouse and a foreign spouse living in the United States or Canada or some other country goes bad, and the Japanese spouse brings the children back to Japan, and the foreign spouse can not only not get the child back from Japan, but frequently can't even have any contact with the child. Retention refers to when the Japanese parent brings the child back to Japan for summer vacation, say, to see the grandparents. It just stays there. And this happens whether or not there is a court order in place, if there's a U.S. or Canadian court order in place, or the visitation is part of court-sanctioned visitation. It still happens. And I refer to Japanese parents doing this, but there are cases of foreign parents actually using the Japanese legal system as a shield against other foreign parents. Some more useful data in the resolution. A large number of marriages between Japanese and foreign nationals. The United States Office of Children's Issues has a number of open cases involving U.S. citizen minor children being abducted to Japan or detained. And I give various versions of this talk, and I gave a version of this talk at the University of Washington a couple of years ago, and one of the people in the audience said, well, why is abduction? Why is it abduction for a parent to take their child back to their own country? And the simple answer is because the law says it's abduction. In the United States, there's the Federal Parental Kidnapping Act, which makes a felony to basically unilaterally take your child to another country. And the Canadian Criminal Code has a similar provision. And even though it may be the parent's home country, it may not be the child's home country. The child may have visited, never actually lived. Another interesting piece of data here. Since the signing of the Treaty of Peace with Japan, 1951, no child has ever been brought back from Japan after being abducted there by the parent. A very common theme in all of the criticism and appeals to Japan to do something about this problem is that Japan is the only G7 country, which is sort of code for, yes, advanced nations or something, that has not signed the Hague Convention on the civil aspects of child abduction, which I'll talk about in a minute. So this is the United States. The United States, and here's some, there have been a variety of both unilateral, bilateral, and multilateral diplomatic efforts to get Japan to do something about this problem. Here's some more examples. There have been joint demarches, joint public demarches, joint private demarches. Really, I think, quite unusual. We have diplomats from multiple countries holding a press conference in that country, calling upon the country to effectively change its law and its legal system. Canada, actually, for a long time, the United States has been publicly quite quiet on this issue, but behind the scenes it has been very active. The United States has, I think, a much more complicated diplomatic relationship with Japan, and there have been various issues relating to U.S. bases that have really been at the forefront of the relationship until now. But and I think the Canadian government has, in many ways, been has both been the primary actor in calling upon Japan to do something, but in some ways, I think it's also been a proxy for the United States in putting diplomatic pressure on Japan. I think at least from 2004, 2005, the embassy in Tokyo has pretty much every year had a symposium on the issue of parental child abduction in Japan. I've been a speaker and participant in a number of these fora. And again, the Canadian experience is the same, that no child who's ever been taken to Japan, even in violation of the Canadian court order, has ever been returned. I've had conversations with diplomats involved in these cases, and they've said things like, well, we've gotten children back from Lebanon, we've gotten children back from Iran. Basically, the only country in the world that they've never been able to get a child back from is Japan. And again, a factor in a commonly identified factor behind the problem is that Japan is not a part of this convention, the Hague Convention on the International, the civil aspects of international child abduction, which is not just a G7 thing. A large number of countries, a big chunk of the international community has acceded to this convention. And what this convention says, in very simple terms, is that children who are wrongfully taken from one jurisdiction to another should be promptly returned to the jurisdiction of what's called habitual residence, as between signatory countries. And what this means is that a court in a Hague Convention country is supposed to refrain from doing what courts always want to do in a case involving a child, which is determine what is in the best interests of the child. Courts generally, in most places, family courts are generally able to revisit what is in the best interests of the child at any time. So the problem in an international abduction case is the court in the new country looks at the child and says, well, the child is in school now and used to their new environment, so it's in the best interest of the child that not change. What the Hague Convention basically says is you should not do that. The only inquiry that a court should make in these cases is an inquiry into whether the child has been wrongfully removed from the other country. And if the child has been removed, they should go back. So, and this convention applies whether or not there are pre-existing custody rulings in the other country. So frequently there are preemptive abductions where the parent, before the divorce proceedings, before any sort of court proceedings have been initiated in the child's home country, the parent just grabs them and goes back to their home country. Again, the Hague Convention is supposed to prevent that by looking at, well, where has the child been living to until now? That's where the best interests of the child should be determined. So we have this identifiable problem that Japan has not signed the Hague Convention. And there are numerous cases of children being taken to Japan, kept there, one parent being denied all contact, all access with their child in Japan. Now, a common response, or another common theme in the discussion of this issue is the issue of, well, Japan is not a Western culture. Japan has a different way of doing things, different traditions. There's this notion that somehow Japanese culture is at work here. And I have to say, having practiced as a lawyer for a number of years in Japan, represented various foreign companies trying to do things in Japan, a common theme of Western American companies as they come to different countries, we want to do things, we want to respect foreign culture, we want to respect your culture, which is it's a great thing. We want to do things the Japanese way, which is sort of like walking into Best Buy and saying, I want the extended warranty, I want the rust protection plan, and we'll do whatever. There should be more inquiry into, well, why do things work this way in this country when it comes to the legal system. Modern countries, I think, have legal systems that were designed by people, operated by people, were entirely artificial constructs. So you should be able to identify some people-related reasons as to why things are working in a certain way beyond some mystical notion of culture. And I don't think the fact that it's Japan makes any difference. And some of my law students have really seen some of this discussion. But what happens, sorry, it's easier for me to see the slides from here. What often happens is there's now this understanding that once your children go to Japan, it's hopeless. The U.S. Department of State Office of Children's issues website, there's this notation saying that no child has ever been brought back from Japan. Japanese courts do not enforce family, foreign court orders regarding the custody of children and so forth. And this actually results in, this happened last year, a very high-profile case of an American who was arrested for basically trying to grab his own children and take them to the U.S. consulate in Fukuoka, which is kind of a mistake because the Japanese police guard the American consular facility, so if they're looking for you, then you're not going to get the gate. So he was arrested for basically grabbing his children off the street after they had been brought to Japan by their Japanese mother in violation of a Tennessee, I believe it was, order awarding him full custody of the children. So in his mind, he has full custody. Why can't he do that? And grabbing children and taking them is, on a certain level, just what the mother did anyways. So this was it was very interesting to watch the media play on this, because it almost immediately got high-profile coverage on CNN, on the BBC, on Good Morning America. The Japanese media didn't really pick up on it at first, and they picked up on it as well. Of course he was arrested. He grabbed his kids, from their mom in broad daylight, and the police were called. Of course he's going to get arrested. Whereas the Western coverage was really, well, he had no other choice. Japan is a terrible place. And that's where both sides of the debate sort of get into these cultural arguments, cultural excuses, none of which are particularly appealing. Now, I just always like to give a couple examples of cultural arguments, because I think particularly in the West there's this view of culture as something that other people have. This is a famous, a well-known commentator on divorce and family issues in Japan. She's talking about, this is in a chapter in a book about visitation rights in Japan, opposed to divorce content. This sort of standard Confucian explanation for the role of children in the family and how children are viewed in the family. Confucian background for continuing the bloodline in the household. Important children are highly valued, as will continue the family line. And then she goes on to say, Western societies, which unlike Japan are gun cultures with a long history of incest, there are many cases of children being abducted, raped, or murdered by the non-custodial parent after the war. So, how do you like that? Cultural argument, child raping, gun toting, whatever. This isn't about family law. There's also a useful example. This is about the death penalty. Just for the sake of speed, I'll skip through to the key statement. This is an explanation of why Japan still has a death penalty where it has been abolished in Europe and most other Western countries except for the United States. Europe is a civilization of power and struggle. Civilizations of power and struggle are different. Their ideology does not value human life as highly as Japanese people. So Japanese people value human life more highly. That is why Japan still has a death penalty. But it does actually make sense. I know it's not relevant to this discussion, but this is actually was made at the time by a man who was the Minister of Justice. So there's another sort of explanation of culture in a legal context, which I don't think is particularly useful, other than sounding vaguely convincing, but not really having proof to back it up. Now, getting back to the issue of abduction, what is coming out on the Japanese side of the debate is, well, actually, most of the cases of international abduction are for Japanese women fleeing from abusive foreign husbands. And that's a number of lawyers and other people have voiced opposition to Japan acceding to the Hague Convention on the ground that Japanese women living abroad will then will have to live in these abusive environments and won't be able to come home, which is sort of a natural instinct. Now, there's absolutely no backing for this, other than this. There's this one lawyer, Mr. Onuki, who's sort of made the statement to the press that seems to have been re-reported everywhere, based entirely on his own experience. This has become sort of one of the foci of debate on the issue of whether Japan should sign on to the Hague Convention. Again, this seems convincing on the surface, but then you sort of say, well, what about the other 82 countries that signed the Hague Convention? What do they do with the issue of domestic violence? And it is an issue that is discussed. And, well, does that mean that Japan has a better set of systems in place for dealing with domestic violence than the United States, than Canada, than Australia, than England? I don't know. I've certainly heard plenty of horrific stories of foreign women married to Japanese spouses being subject to violence and receiving, really, not only not receiving any assistance, but actually being locked up by the police until their Japanese husbands come and get them and call the embassy and try to get help that way. And if you accept this, then you probably need to accept foreign spouses of Japanese husbands fleeing from Japan with the children to escape domestic violence in Japan, which I don't think anybody participating in the debate really thinks about. Now, what's really misleading about the entire debate is that it's not an international problem. It's pretty much discussed largely on both the foreign side and the Japanese side as the issue of foreigners versus Japanese. But in fact, the real problem is a domestic one. The parental abduction, denial of access, post-divorce, post-separation, parental alienation is a much larger problem for the average Japanese person than it is in international cases. The international cases are the tip of the iceberg. So to look at what some of the legal issues are, parental abduction is not a crime. This is actually something that diplomats sometimes come to me and ask about. It's like, well, whenever we come to the foreign ministry or the justice ministry in Japan and say, this child has been abducted in violation of a U.S. court order or in violation of the Canadian court order, there's an arrest warrant out for this parent based on this. we would like, please help us get the child back. And what they're always told is, if it's your own child, it's not a crime in Japan. It's not a crime to abduct your own child. Common response, and then last year, I think somebody's arrested for abducting their own child. So I've been asked by different diplomats, well, when is child abduction a crime in Japan and when is it not? Just the question itself reflects a very Western view of the law, which is that it's a clear body of rules that are knowable in advance, which it doesn't actually necessarily need to be. The police don't get a corollary of that is that the police will not get involved in these sorts of cases unless, for whatever reason, they decide to get involved. But when we start talking about enforcement, police, there are no people with guns and a badge and handcuffs who will come to the door of a recalcitrant party and force them to comply with the court order, whether it's a foreign court order or a domestic court order. There are a number of issues in the Japanese family law system which relate to this problem. Really, there's sort of this even a debate about whether there is such a thing as a family law, because in Japan there is. But technically, such family law as there is really concerned primarily with the establishment and destruction of formal kinship relationships. And under the current family law system, it's based on marriage and the parent-child relationship. But, for example, there's a very easy regime of consensual adoption. It's very easy to adopt another person as your child. It's very easy to consensually terminate that relationship. And it's the same with marriage. It's actually, Japan is actually a very easy place to get married. It's actually a very easy place to get divorced if both of the transactions are consensual. So there's very much a form over substance element to the family relationships which are formally defined in the law. And these actually relate to what's called a family registry. It's almost like a property registry, the registry in which the family relationships are recorded. And what you can record in the family registry sort of defines the acceptable types of family relationships. But a corollary of this is that the formal statutory legal regime doesn't actually have very much to say about, well, what is the status of these formal relationships after one of them has been, after they've been terminated. So, for example, there's nothing about post-divorce parental access. There is really nothing about what rights do you have to your children if you're the father and the child is born out of wedlock. Really, there are no rights. As I said, it's very formalistic, and it's very binary. There's no joint custody after divorce, so custody litigation is very much an all or nothing battle to the death, where basically one parent gets everything and the other parent really doesn't get very much unless the parent who is the custodial parent can be convinced to agree to it. The best interests of the child don't actually, that's sort of the standard for custody determinations everywhere, but in the vast majority of cases, the best interests of the child are relevant because, again, there's this preference for consensual termination of arrangements. So 90% of divorces in Japan are cooperative divorces. You don't even go to court. You go to your local government office, fill in the divorce, submit the divorce papers, and boom, you're divorced. It's so easy, actually, that local government offices have had to develop a procedure for refusing to accept fraudulent divorce filing, because you can actually just grab your wife or husband's personal seal and fix it to the divorce papers and get a divorce without the cooperation. So there's this mechanism for not letting that happen if you think your spouse is going to pull a fast one on you. Custody arrangements as well. On the divorce paper, there's a column you fill in which child goes with which parent. And that's it. The court, nobody ever gets into what is in the best interest of those child. So you can have an arrangement where there was actually a very horrific case in Nara a few years ago where a teenage boy was under such tremendous pressure from his doctor father to study to be a doctor himself that he ended up burning down his own house and killing his stepmother and young half-siblings. And his parents, his natural mother got divorced from his father, and it was a cooperative, it was a sort of negotiated divorce, but part of the divorce arrangement was that he never saw his mother again, and he was separated from his other natural siblings. And the courts, nobody looks at those divorces to see what's in the best interest of the child, because it's just presumed that if the parents agree to it, then it's okay. And 90% of divorces are consensual without court involvement. Even the majority of divorces where courts are involved, there's a requirement that there first be mediation. So most of the remaining divorces are mediated divorces where the court provides the mediators in the meeting room and encourages people to develop a correct understanding of what their responsibilities are. But again, if the parties in mediation, mother and father, agree to a result that objectively is bad for the child, it's still okay. And this type of mediation is sometimes called hostage-based mediation, because one parent has the child, and because of mediation, the court won't really do anything in terms of providing interlocutory access, for example, while mediation is in the process. So you can keep mediating if you're the parent who hasn't seen your child for 3 months, 6 months, a year, but every mediation session is basically another month where nothing's going to happen on that with your child. So at some point, many parents who lose access to their children through the system end up agreeing to whatever financial and other aspects of the divorce that everybody wants. Again, that's okay because it's formally it's a negotiated consensual arrangement. And this requirement even applies when there is a foreign court order. So parents who show up with an arrest warrant for the abducting parent with a court order from Canada or the United States or some other country saying, this issue has already been litigated in the best interest of the child, has already been determined in another forum, the first step is still typically mediation over what we're going to do next. There is very limited, it's rapidly changing, but the notion that one parent should disappear after divorce is still fairly strong in Japan. When courts do award visitation, which they actually are very reluctant to do if both parents don't agree on it, it can be something like, there was this one I read about it last year where the judge denied the father visitation but ordered the mother to send 2 photographs of the child. I've met people who've gotten 6 hours of visitation per year with their own children. 0 hours. Another common strategy that I've seen is if the child is a teenager, then say, well, wait till the child is an adult, and then they can decide themselves whether they want to have a relationship with their absent parent. Part of the reason why this happens is because there are no clear statutory guidelines for what is in the best interest of the child. It literally is left up to administrative determination of the judiciary. And the judiciary is a bureaucracy, and it has its own very institutional issues, institutional dynamics, which determine how it acts. So I commonly say that, well, to understand how the best interests of the child are understood in Japan, you really have to understand what's in the best interests of the judiciary first. Most court decisions about children, I think, really take into account the best interests of the judiciary, which is too long a subject to go into in any great depth, but there's docket clearing, there's not being overturned on appeal, and a number of other issues. Because there is no clear statutory law on what's in the best interest of the child, a lot of what law is out there is sort of judicially created. There's very limited, what we would consider a shockingly limited regime on visitation has been created judicially. There's this overwhelming preference for mothers. Mothers pretty much always get custody if it's left up to a court to decide. Some foreign parents believe that there's a favoring of Japanese parents versus foreign parents in Japanese courts. It's hard to tell because so many of the cases are foreign men versus Japanese women. You don't know whether it's the gender bias versus a racial nationality bias. I do know one foreign embassy group that sent a delegation to the Tokyo Family Court and said, look, what's happening with your cases involving our nationals? And the Tokyo Family Court reportedly told them that in the case of a foreigner versus a Japanese parent, the court would always award custody to the Japanese parent because the Japanese parent had a family registry, and only Japanese people have family registries. So you can sort of picture the bureaucratic problem there, which is how can you have a Japanese child in Japan without being on some adult's family registry? It's sort of a comprehensive problem, but it shows how simplistic these determinations of what is in the best interest of a child are reduced to. I have spent the last several years talking to numerous parents who have participated in various types of Japanese custody proceedings, both Japanese parents and foreign parents. I've seen all sorts of iterations. I've seen Japanese parents. I know one Japanese mother who was married in Canada to a Japanese spouse, and the Japanese husband brought the child back to Japan in violation of the Canadian custody order. I know foreigner versus foreigners in Japan cases. I've seen them all. And pretty much every parent I've ever dealt with in these situations sort of expresses shock at the treatment they get in Japanese courts. They don't understand, there's no logic to it, the way the Japanese courts seem to act. And the Japanese courts don't seem to always follow the law, but that's if you look at the law as something that's there for you, the parents, the parties, rather than a set of tools that this judicial bureaucracy uses to get cases off its own. If you look at the issues through the perspective of what does the court need, how does the court need to decide things, what does the result need to be for the court to do its job, then things make more sense. They're not necessarily more pleasant. Now, one of the things that frequently gets cited in by parents, both Japanese and foreign parents, is that Japan does not comply with its rights under its obligations under the UN Convention on the Rights of the Child, which include the right of children to know and be cared for by their parents, the right of children to preserve their identity, which includes family relationships, and the right of children to have ongoing contact with their parents if they're separated from them for whatever reason. Japan's report on these, the Japanese government reports every 5 years on its compliance with the UN Convention on the Rights of the Child. Article 7, for example, says, well, children can go and look at their family registry and find out who their parents are. That's so complying with that, with the right to know your parents. And some of these other areas, they don't really address in any great detail. Because parental separation, being denied ongoing contact with one of your parents after parental separation requires some sort of determination that ongoing contact is bad for the child. Japanese courts have developed jurisprudence which seems to assume that Japanese children are exceptionally frail and weak because buying too many presents for your child can be grounds for having your visitation terminated. I know one gentleman whose visitation with his children was terminated because the thought of him seeing her children made his ex-wife physically ill. If you look at what's written on visitation in Japan, the list of things you can have your visitation terminated for is exceptionally long, but there's this underlying logic that visitation has to be bad for the children. So there's a lot of things in visitation are interpreted as being bad for the children. Now, the calls on Japan to join CAPI, the Hague Convention, have been going on for a number of years now, for certainly as long as I've been following the issue, which is being on 6 years now. But there's also been a domestic agenda, because there are many Japanese parents who, in strictly domestic cases, suddenly find themselves losing all access to a child they've been caring for. And this is primarily fathers, but mothers as well. Their issue is really an adoption of a joint custody regime, together with a more clear statutory enumeration of visitation rights. And this process is actually being advanced on a number of fronts. It's actually, just this process would be something interesting to look more into, but a fairly small group of parental rights advocates are both lobbying the national legislature, but they're actually also lobbying municipal and prefectural legislatures, getting those legislatures to pass a resolution calling on the national government to adopt a joint custody regime. So if you look at books on family law that were written even just 5 or 6 years ago on the subject of the possibility of joint custody in Japan, they just say, well, the national sentiment is against it. Literally, that's legal reasons. National sentiment is against it, period. But now there are a number of legislatures, the Osaka Prefectural Legislature, not a small political body, has issued a formal resolution calling on the national government to adopt a joint custody regime. There now appears to be a government media campaign. It's almost like somebody flipped a switch from basically last year. The mainstream media has been taking up the issue both of the Hague Convention, but also joint custody, parental rights, post-divorce. So I was actually, over the weekend, somebody called me, asked if I would go in and talk with the Japanese Prime Minister about what the issues are here. I had to decline. It looks like it's not happening, but it's getting a very high level of attention now. There is some opposition, both from conservative political interests, bureaucrats. There are certain some women's rights groups object to it, again, because part of it is domestic violence. Again, they don't want to have any more exposure to abusive spouses. They don't want the interference that would come with the joint custody regime. So it's not clear where anything will go. The great elephant in the room about anything written about Japanese law, particularly family law, is that nothing's really enforceable. Courts literally do not have any really powerful remedies to use against a party who doesn't play by the rules, who doesn't do what a court orders them to do. So whether changes in law will do anything is a question. I have habeas corpus up here, because habeas corpus is the ultimate remedy the Japanese courts have in bringing about the return of an abducted child. The police can hold you for 23 days without any access to a lawyer, and habeas custody is used in child custody cases. So you know you're in a different country. But habeas corpus is the only judicial remedy that has any sort of hint of penal sanctions for noncompliance. But it's sort of the final weapon when all other remedies have been exhausted. But when a child is at issue, by the time you get to all of the other remedies being exhausted, the child has been in a new environment for 2 years, 3 years, and changing that environment probably is not going to be in the best interest of the child. so it's rarely used. So my own personal view is a lot of what happens in these cases involving children, involving abducted children, it's particularly noticeable in cases where children have been abducted from Japan. There's almost, I think, courts using their interpretation of the law and their procedure to sort of hide the fact that they really can't do anything to preserve their institutional integrity by spending a lot of time saying that the status quo is a good thing. I suspect that Japanese courts have become sensitive to criticism that they do not respect foreign court orders. That's a common theme in some of what you'll see written on the subject. But I know of cases where a foreign custody order has been affirmed all the way to the Japanese Supreme Court. I know of cases where a Japanese court has refused to accept jurisdiction from a Japanese mother who has brought the child to Japan and seeks to amend a foreign custody order. The court says, go back to the country you're living in. The end result in all of these cases is the same, which is that the child stays in Japan because there's nothing happens if you don't go back to where you came from. Nothing happens if you remain in violation of a foreign custody order that has been affirmed by the Japanese Supreme Court. So enforceability is and will probably remain the elephant in the room about this debate, because how do you, once the court decides something, how do you actually make that happen? So what comes next? I don't know. So I guess I should have had more of a clear answer if I hadn't used the title as a teaser. What comes next? I guess I should have had an answer. But a scenario I see happening is that Japan accedes to the Hague, adopts the joint custody regime, and nothing actually really changes. I think a useful reference is that Germany, which is a Hague signatory, has long been identified as a non-compliant party for largely the same reasons that Japan has problems, which is that the German law, as I understand it, doesn't have any mechanisms in place for enforcing the handover of the child. So Japan could end up a signatory and immediately go on various lists of non-compliant countries, because the issue from the Japanese perspective is to actually make the Hague mean something. You really have to go very deep into both family law and the position of the courts, the amount of power the courts have. You have to make some very profound changes to the domestic legal regime for any of that to make a difference. For the Hague Convention to actually mean something in terms of really bringing about the return of the children. And the same with joint custody. Japan could adopt a joint custody regime and say what courts already basically say about visitation, which is we'll award it, we'll recognize it if both parents agree to it. If joint custody is simply adopted as a judicial option, then yeah, nothing much could change. It'll take another 10 or 20 years for pressure to build up to make further changes.